this is the first time that this court is doing court via their own YouTube channel. Remember, Judge John Judge kicked the media cameras out of the courtroom, absolutely yeeted them, and said, you know what? If y'all aren't going to follow my order and you're going to zoom in on the defendant's face and the rest of it, you're not going to get to do this. I'm going to do it myself. And that's where we find court today with John Judge saying, I'm going to do it myself. Here's what happened today in Idaho. Judge John Judge had an entire hearing sealed to the public regarding the indictment of Bryan Kohberger. Then in the public hearing, he heard a motion for reconsideration, which is the defense asking the judge to reconsider his prior ruling with regard to the standard of proof needed for an indictment. The defense is arguing that the standard of proof a grand jury needs to indict is beyond a reasonable doubt. Judge Judd previously ruled, like every other court everywhere in the US, that the standard is probable cause. Same for grand jury, same for prelim, same for pronouncement by judge. Probable cause. The defense asked him to think again about that, Your Honor. Would you please reconsider and change your mind? The court said no. Then they asked for leave to file an interlocutory appeal. An interlocutory appeal means during the proceedings of this case, the entire case would stop while that question goes up on appeal, arguing from the defense that this case cannot move forward until that decision is decided. The judge said, yeah, we're not doing that either. This is not a unsettled area of law. Literally all the courts agree. You're the only one that disagrees with this standard, and we're not going to do that. Will the defense perhaps still try to take an appeal up to the Supreme Court of the state of Idaho? Yeah, probably. Is that going to go very well? No, not really. This is not an area of law where it's like, well, they have a strong argument. No, they don't. No, they don't. This one is an absolute reach. They've done it respectfully. They've tried to argue that the Magna Carta set a different standard for juries because it's a grand jury and it should all be beyond a reasonable doubt, but that's not going to fly. That is not the law of the land. Then they got into a scheduling conference that was respectfully argued, but difficult. The defense is saying that there is no way that they can be ready for trial in this quadruple homicide before the summer of 2025. Sometimes I misspeak as to dates, but you heard me correct on that one. Summer of 2025 is when the defense wants to set this trial. The prosecution argued this trial needed to go to trial in the summer, and it needed to be summer of 2024. Ann Taylor did an excellent job of thoroughly laying out the fact that she could not be an assistive and effective counsel for Bryan Kohberger without that much time. And she is setting up the argument on appeal later that if she is not granted that much time, that her argument will be ineffective assistance of counsel, or the appellate attorney would argue ineffective assistance of counsel because she said she needed that time and was not given that time. Ineffective assistance of counsel can be strong grounds for appeal after conviction. She talked about how much work is needed to be done in the penalty phase of the trial and how much work is needed to be done in the guilt phase of the trial. So the first phase of this trial will be, is Bryan Kohberger guilty or not guilty? And the second phase will be, and then what punishment? Life without parole or the death penalty? She talked about how much work goes into both of those phases and indicated that combined there could be over 500 witnesses in this case, and that she believes this trial is going to take 12 to 15 weeks of trial. The judge did not make a decision in Idaho and wants to take it into consideration, considering that these murders took place over a year ago, and the delay and the stress that that delay causes on the families of the victims. However, if the defense does not have effective assistance of counsel, that is an appeal that could cause any conviction to be overturned in the future, meaning that justice will not be settled for the victims' families if that happens, putting the judge in a position that he does not like, because even the prosecution started to acquiesce that this trial might have to go to trial in summer of 2025 which is likely what the judge is going to do. For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.